Okay, let's just dive right in. Today, we're demystifying the Mississippi legal system and empowering you to handle a minor financial dispute completely on your own. Honestly, if you've ever felt totally overwhelmed by the mere thought of stepping into a courtroom, or if legal jargon just makes your eyes glaze over, you are absolutely not alone. But today, we're going to break the whole thing down.
So, ever wondered how to actually file a small claims case in Mississippi without all the usual stress? Well, by the end of this explainer, you're going to be fully equipped to navigate the entire process like an absolute pro. We're taking a system that feels totally impenetrable and making it 100% actionable for you.
Here's our quick roadmap for how we're going to do this. We'll start with a welcome to justice court, then we'll hit the eligibility criteria, preparing your case, the step-by-step filing process, what to expect on your day in court, and finally, judgments, appeals, and a few disclaimers.
All right, Section 1. Welcome to Justice Court.
Now, you might be surprised to hear this, but Mississippi doesn't technically have a structurally independent small claims court. Nope. Instead, your case goes through the civil division of what's called the Justice Court. There are 82 of these courts scattered across the state, featuring 198 elected judges. People affectionately call it the Court of the People, mostly because it's designed from the ground up to be super accessible. The rules and procedures are way more relaxed, specifically so you can represent yourself, which, by the way, is called proceeding pro se in the legal world, all without the massive, terrifying expense of hiring a lawyer.
Moving right along to Section 2, meeting the eligibility criteria.
Look at this number, $3,500. That is your magic number. In Mississippi, the absolute maximum monetary limit your claim can be is $3,500. Believe it or not, that's actually one of the lowest jurisdictional limits in the entire country. So what does this mean for you? Well, if someone owes you, say, $4,000, and you try to file in justice court for that full amount, the judge literally has to throw your case out. To take advantage of this fast-tracked, lower-cost court, you would literally have to waive your right to that extra $500. If you absolutely want the full $4,000, you're going to have to file in a higher, much more complex court, like a county or circuit court where, let's be real, you'll almost certainly need to hire an attorney. So what kind of drama actually belongs in justice court? It is perfect for things like broken contracts, unpaid debts, personal property damage, and landlord-tenant headaches like evictions or fighting over security deposits. But, and this is a big but, it totally lacks the authority to hear disputes over real estate titles, family law, divorces, or child custody. Oh, and this is absolutely crucial, it cannot issue injunctions. That means a justice court judge cannot legally force someone to do something. They can only order them to pay you money.
Okay, Section 3. Preparing your small claims case.
3. That is your timeline. You generally have exactly 3 years under Mississippi's statute of limitations to file a lawsuit for a written contract, an oral contract, property damage, or a personal injury. Let's put that into perspective. If your neighbor backed into your fence 4 years ago and you're just now deciding you want to sue them, I've got bad news, it is too late. The law places a strict timer on your right to seek a legal remedy, so whatever you do, don't just sit on your claims.
Let's look at some real-life stuff that fills up justice court dockets every single day. Picture this. You moved out of an apartment, left it spotless, and your landlord is unfairly hoarding your security deposit. Or maybe you're a freelancer, and a client is just totally dodging your invoice. We see tons of property damage from fender benders or private loans between former friends that magically never got paid back. And hey, fun fact, if you're dealing with a bounced check, Mississippi law actually allows a statutory penalty of double the check's face value or $200, whichever is greater. So if any of this sounds painfully familiar to you, your frustration is totally valid, and Justice Court is literally the tool designed to help you fix it.
All right, Section 4. The step-by-step filing process.
We are going to walk through these 4 steps methodically, so grab a pen. Step 1 is absolutely vital. You have to identify the correct venue. You must file in the county where the defendant resides, or where the incident actually occurred. If you file in the wrong county, boom, immediate dismissal, and you just lost your filing fees. Step 2, complete a sworn statement of claim at the clerk's office. This is just a simple form where you list who you're suing, for how much, and a quick chronological story of what went down. Step 3, pay the filing fee, which usually runs somewhere between $84 and $100 depending on your county. And finally, Step 4, serve the defendant. You usually do this by paying a court constable to hand-deliver the lawsuit, or you can use certified mail. Bottom line, if you don't prove to the court that the defendant was officially served, you are not getting a judgment. Now, earlier I mentioned that $84 to $100 filing fee. Look, in a court where the max payout is $3,500, that's a pretty high entry cost. It can eat up 3 or 4% of your total claim right out of the gate. Well, if you simply cannot afford that, Mississippi law has a brilliant little workaround called in forma pauperis, or a pauper's affidavit. Let's translate that heavy legal jargon into plain English. It's basically a sworn statement you can use to waive your filing and service fees if you are indigent. The whole system is designed to make sure justice stays accessible even if upfront court costs are a huge barrier for you.
If you do need to request that fee waiver, here is exactly what you'll need to swear to. It states, "I do solemnly swear that I am a citizen of the state of Mississippi, and because of my poverty, I am not able to pay the costs or give security for the same in the civil action, and that, to the best of my belief, I am entitled to the redress which I seek." Once you file that, the clerk actually has to accept your case. Just keep in mind, the judge or even the other party can challenge it later on if they suspect you aren't being totally honest about your financial situation.
Which brings us to Section 5. Your day in court. Get ready because things move pretty quickly once you file. Hearings in justice court are typically scheduled within 30 to 70 days of your filing date. Of course, if you live in a really crowded county, it might lean closer to that 70-day mark. And here is a super important detail. There is no jury in justice court. You aren't going to be putting on a theatrical performance for 12 of your peers. It's just you speaking directly to a single judge and answering their questions. And usually they'll give you a ruling right then and there from the bench.
So how do you actually win? By being meticulously, obsessively prepared. Here is your ultimate court day checklist. First, dress respectfully and always address the judge as Your Honor. Second, bring physical evidence. If your claim is based on a contract or an invoice, bring it. If someone smashed your fence, bring printed photos. Third, if someone actually saw the event happen, bring them to testify in person. Judges almost never accept a written letter from a witness. Fourth, and this is a massive pro tip, make 3 copies of every single document. One for the judge, one to hand to the defendant, and one for you to look at while you're talking. Finally, just be ready for questions. Build a strong, clear, chronological narrative, stick to the cold, hard facts, and please leave the emotional venting in the parking lot.
Almost done. Section 6. Judgments, appeals, and disclaimers. Okay, imagine this scenario. The judge rules in your favor. You won. Awesome, right? But here's a very harsh reality of the legal system that catches so many people completely off guard. The court doesn't automatically collect the money for you. A judgment is basically just a really powerful piece of paper verifying that yes, this person owes you a specific debt. But if they still refuse to write you a check, you have to actively enforce that judgment yourself. You might actually need to file more paperwork to get a wage garnishment, where their employer sends part of their paycheck directly to you, or a bank account garnishment, or maybe even a writ of execution where a sheriff literally seizes their assets to sell off. And you know, we also have to talk about the alternative. What if things go sideways and you lose? Or what if you win, but the defendant flat out refuses to accept it? Well, either party can appeal the decision. But listen closely, you have a strict 30-day window from the date of the judgment to make that happen. And an appeal from justice court isn't just someone reviewing your old paperwork. It literally starts a fresh trial from scratch in a higher court, like a county or circuit court. Also, just to keep people from appealing over every little thing, the appealing party is usually required to post a cost bond covering the judgment amount and the court fees up front. Finally, before we wrap up today, please remember our mandatory disclaimer. This explainer is for informational purposes only and is absolutely not a substitute for real, professional legal advice. Every single case is totally unique, and if you ever feel uncertain at any step of this process, please reach out to a Mississippi legal professional. But hopefully, armed with this roadmap, the whole system feels at least a little bit less intimidating. So I want to leave you with this final thought. The next time someone breaks a contract or damages your property, are you going to let the intimidation of the legal system stop you? Or are you going to use these very tools to demand the justice you deserve? Thanks for joining me.